what's your thinking generally around the ruling of the court and the application made by the Office of the Special Prosecutor to the court?
Okay, yeah, so Selorm, there are two applications. They were conjoined. In law, we call them double barrel applications, right? Two in one. So the first one is to asking for confirmation of the currency that was seized in Madam Dapaah's house. That's the $590,000 and the 2.7 million. So that one falls under Section 32 of the Act. You see, when you seize property, then you should go for confirmation. That's Section 32. That's the one that says come within 7 days. Then also there is the freezing of the account. So that's under Section 41. So it starts from the 38, blah, 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 blah. But 41, so the actual application is under 39. Yeah, so from 38, 39, 40 to 41, effect of freezing and all.
That's the freezing, yes.
Yes, okay, duration. So let's just go. 39 talks about the application. So it's the freezing of the account that falls under 39. Now,
but 32 talks about the seizure.
So that's the fiscal. The court, can you imagine $590,000? So that's almost 12 million Ghana. So the summary of my submission is that for the seizure, I'm not with the judge. I think he could have done something about it and not say that the money be returned. But when it comes to the freezing of the account, the judge is spot on. You can't send a judge a clean, an empty sheet for him to fill in for you. What prevented OSP from giving details? You see, he didn't give details of the account. And if OSP was scared that, and I can appreciate practically, Selorm, you know, the 5 million that we've all had, yes, it's not a 5 million balance in the account, but volume of transactions. Maybe today somebody pays in $50,000. The next day somebody pays in 1 million. Maybe 5 months later somebody pays in $1,000. So it's a volume that came to 50. So I can 5 million. I can imagine that there are different people who did these payments and different companies. So if you just put the statement out there in the public, it's likely to trigger a big storm. All these people will start running for cover. And you can imagine how they can frustrate the work. I appreciate that practically. So what Mr. Cecilia Dapaah should have done was then to apply to the judge that you want to have an in-camera hearing so that you can show him, so that we don't mind. You can just only give us details in the affidavit that the total is 5 million here, and then 48 million Ghana. It's not one person who paid it. Oh, trust me, from what we are hearing, different people paid 48 million Ghana in the Citi account, then 5 million in the dollar. That's the total volume. So it's not certain balances. So tell him that no, if we put these things out in the public, it will jeopardize the investigation. Any judge will understand. Then you can do your in-camera hearing. It's like, you see, a judge would understand. But when you totally ignore this and you just go down investigating Madame Dapaah, so because of that freeze the account. No, it doesn't work that way. It doesn't work. So as for the unfreezing or defreezing, the defreezing, I had heard we couldn't use the word defreezing, but today I just Googled it and I saw.
Yeah, I thought defreeze. So it's always confusing.
So you can use
or
the
defreeze. Okay.
Now look, the English language is not like one word, kids. There are so many. Yeah, there's
a lot of dynamism in
English.
English.
Thank you. That's the word dynamic. So unfreezing and defreezing, you can use them interchangeably, right? Yeah. So that one he got it wrong. So Mr. Jabin, what he can do is to reapply. Selorm, you know it under the principles in the what. Van der Poel versus Nati, and then ex parte Andreas Hesse. You can always repeat an application. Yeah, when you have new facts.
Yeah, but new facts, change circumstances, etc. But where will it come under?
And so you say new facts.
New facts. But the facts have already known.
Yeah, right now, you know, we have heard it through the grapevine. So I'm sure that one, you know, the judge is not likely to heckle him. Because reapplying, Honorable will tell you, if you reapply, he has higher chances of getting the freezing order than appeal. Because if you go on appeal, it is these things you put before the High Court that will be used. On appeal, he cannot bring in those statements. He cannot. So it's rather better any day to go and try to show the judge the statements, then your chances are higher. So that, you know, if the judge were even to refuse to hear the application, in camera, then you run under Article 135, the public interest and national security. You go to the Supreme Court that no, you don't want to disclose these things publicly. So let's look at 135. It says, the Supreme Court shall have exclusive jurisdiction to determine whether an official document shall not be produced in court because its production or the disclosure of its contents will be prejudicial to the security of the state or will be injurious to the public interest. So this one, not national security, the public interest in what? Proper investigations. If I put out these statements, all the people who see their names, yeah, they'll give me headache. And you know, Mr. Jabin, I said it elsewhere, he granted an interview the day he said he's the conscience of the nation. But he said what he's most scared of is what? The chiefs. So as soon as, so if you are smart, so can you imagine all these people going to his Omanhine, the Kpebu Manhine, to lodge their grievances and begging him to intervene. So he can say, oh, that can scatter. The judge will understand. But you just don't sit and think that, no, he should see that once you say you are investigating is sufficient. No, you don't do that. And of course, I also see that there's a certain context. Selorm, you and I, you see, this OSP Act is new. But when you go out there, so many nations are well ahead of us. The practices when it comes to some of these specialized bodies. So maybe we should make amendments to the law and give more specific provisions, this in-camera hearing and the rest, so that even Article 135, you know, it mandates. Can you imagine the whole Ghana, every time you want to do this in-camera, will you go to the Supreme Court? No, there should be exceptions. And I saw that being done in the National Service case, the case in the previous administration, the National Service Director. Yeah, some of the national security officers and BNI who came to testify, they testified in camera. So Mr. Jabin can take advantage of that. But as for not giving the details, Selorm, you know what? Mr. Jabin should have even also seen that. You see that Madam Dapaah's lawyers were attacking Joy FM. That where did you get the details of the 5 million, the 48 million from? Why don't you give it out so that we can use it for the conversation? Because Selorm, we all know that in bringing about certain changes, sometimes we have to beat the issue in the media well for citizens to understand. Then they'll give support. The courts need public opinion to also run. The judges need public opinion too. So if you see that, the Joy FM is even under attack, hey, use a way to release it.